On July 20th, 2026, President Trump reached into a law that hadn't been used to impose tariffs in nearly a century, a Depression-era statute buried inside the same legislation historians blame for deepening the Great Depression itself. And in doing so, he accidentally revealed the exact ceiling on his own power. Canada's trade lawyers found it almost immediately. What they found changed the negotiation overnight. And once they did, the entire calculation behind Ottawa's calm, patient negotiating strategy suddenly made a lot more sense. This is Finance Signal Daily. This is the story of Section 338 of the Tariff Act of 1930, the law nobody expected Trump to use, why he was forced to use it, and the hard legal limit inside it that may be the real reason Canada never panicked. Let's start with why Trump needed this law in the first place, because the answer isn't obvious unless you understand what happened just months earlier. In February 2026, the U.S. Supreme Court struck down Trump's sweeping tariffs that had been imposed under the International Emergency Economic Powers Act, commonly known as IEEPA. The court held that IEEPA simply did not grant the president the authority to impose broad import duties unilaterally. That ruling eliminated what had been the administration's most flexible and far-reaching tariff tool. For months, Trump had been using IEEPA as his primary legal weapon to impose tariffs across dozens of countries with minimal process. After February 2026, that weapon was gone. So the administration needed an alternative statutory hook, a different law that could still let the president impose tariffs quickly without the lengthy investigations required under other trade statutes. That's exactly what Section 338 offered. As trade analysts covering the shift have noted, Section 338 predates the entire post-World War II trade legal architecture and requires no investigation, no hearing, and no agency report before the president can act. Stephen Brown, chief North America economist at Capital Economics, captured the moment plainly in a research note. Taking a step back, it's striking that the Trump administration is now reaching to a new method to implement tariffs. Here's what makes Section 338 genuinely remarkable as a legal tool. It's part of Section 338 of the Tariff Act of 1930, the same Smoot-Hawley legislation that economic historians widely credit with deepening the Great Depression by triggering waves of retaliatory tariffs worldwide. This is the first time in the law's 96-year history that a president has ever invoked it to impose a tariff. Not once before this, through the Depression, through World War II, through the entire post-war trade era, had Section 338 actually been used to levy a duty. The only trace of it in the historical record is a brief mention in a 1942-43 Tariff Commission report tied to wartime trade control monitoring, not an actual tariff action. Some legal analysis even suggests the provision may have been effectively superseded by later trade legislation passed in 1962. That means there's genuine legal uncertainty about whether this dormant, never-before-used authority can even be applied the way the administration is using it now. On July 20th, 2026, Trump signed 3 separate proclamations invoking Section 338 against Canada. Each proclamation targeted a specific grievance, one covering motor vehicles, citing Canadian tariffs and tariff rate quotas applied to U.S. vehicles since April 2025, one covering dairy products, and one covering alcoholic beverages. Together, these 3 proclamations impose an additional 50% duty covering roughly 554 Canadian tariff lines, according to official trade data. Everything from wine to hockey sticks to cement. According to a White & Case legal analysis, together, these proclamations cover approximately $20 billion worth of U.S. imports from Canada, roughly 5% of the total value of all goods imported from Canada. Notably excluded from the action, energy products, potash, fish, critical minerals, and goods already covered by separate Section 232 tariffs, including steel, aluminum, copper, and automobiles and auto parts. So this isn't a blanket tariff on Canada, it's a targeted strike on 3 specific sectors, with everything else carved out. Here's your first rehook, and it's the detail that makes this tariff fundamentally different from everything that came before it in this trade dispute. The Section 338 tariffs apply to all covered goods, regardless of whether they originate under USMCA. Meaning Trump used this law specifically to bypass the protections built into the very trade agreement governing Canada, the US, and Mexico. That's not a small technical detail. The USMCA was designed explicitly to guarantee tariff-free trade between the three countries on qualifying goods. Section 338 simply ignores that guarantee entirely, treating USMCA-compliant Canadian goods exactly the same as non-compliant ones.
So, what's the legal justification for overriding a signed trade agreement this way? Section 338 lets the president impose duties on a country he determines is discriminating against U.S. trade. Full stop. The USTR, in a statement from Ambassador Jameson Greer, framed this as holding Canada accountable for retaliation against American exports. Legal analysts note the law is conceptually close to the WTO's most favored nation principle, but it predates GATT entirely and includes no exception for preferential trade deals like USMCA. That missing exception is exactly what let Trump bypass USMCA protections that newer trade statutes would have respected.
Now here's where the story gets genuinely fascinating. This is where Canada's legal and economic teams found something that appears to have shaped the entire response strategy we've covered on this channel in previous episodes. Section 338 contains a hard statutory ceiling. The law caps the additional duty the president can impose at 50%. That's not a policy choice Trump made. It's the maximum the law itself allows for this specific action. If the president determines that a country's discrimination continues or escalates beyond that point, his only remaining legal option under this statute isn't a higher tariff rate. It's a complete embargo, excluding the country's products from importation entirely, backed by forfeiture of any goods imported in violation. There is no middle ground written into this law between a 50% tariff and a full trade embargo. Let's get into exactly why this ceiling appears to have shaped Canada's entire response, why legal scholars are already challenging whether Section 338 can even be used this way, and what happens if Trump actually tries to go further. Let's think through what that statutory ceiling actually means for the negotiating dynamic between Washington and Ottawa, because this is where the title's claim that something stopped Trump cold starts to hold up under real scrutiny.
Under Section 338, Trump has essentially exhausted the graduated pressure options available to him through this specific law. He's already at the maximum 50% rate the statute permits for a standard proclamation. His only remaining escalation path under this exact authority is a full embargo on Canadian goods, a drastically more extreme action that would eliminate Canadian imports in the affected categories entirely, not just tax them more heavily. That's an enormous escalation gap. There's no incremental step between 50% tariff and total embargo written into this law. Compare that to how tariff negotiations typically unfold, where a president might gradually ratchet up pressure, 10%, then 25%, then 35%, then 50%, creating a slow-building sense of escalating consequences that pushes the other side toward concessions at each step. Section 338 doesn't work that way. Trump jumped straight to the statutory maximum in one move. There was nowhere left to climb.
That means Canada isn't staring down a slow escalation ladder anymore. It's staring down a cliff edge. Either the current 50% rate stands, gets negotiated down, or the U.S. takes the extraordinary step of a full embargo, an almost unprecedented action against the G7 ally and a founding USMCA partner. This context helps explain something we've covered in earlier episodes on this channel: Prime Minister Mark Carney's calm, non-retaliatory response to this tariff round. If Carney's trade and legal teams understood that Trump had already reached the statute's ceiling, that changes the entire risk calculation. Panicking or retaliating aggressively against a tariff that's already at its legal maximum doesn't create additional leverage the way it might against a tariff that could keep climbing indefinitely. Instead, patient negotiation makes more sense, because the next move available to Washington under this specific legal authority is either de-escalation through negotiation or an embargo so extreme it would represent a fundamentally different, far more consequential decision than anything imposed so far.
Now, let's talk about the legal vulnerability sitting underneath this entire strategy. Because Section 338's dormancy for nearly a century isn't just a historical curiosity, it's a genuine legal risk for the administration. Legal scholars have directly challenged whether this dormant Smoot-Hawley provision remains valid at all. Some argue the authority was effectively superseded by trade legislation passed in 1962, meaning courts could potentially find that Section 338 simply isn't available for the president to use this way anymore, regardless of how the White House chooses to interpret it. The fact that Section 338 has never before been used to impose tariffs, not once in 96 years, adds to the uncertainty. Its only documented historical activity is tied to wartime trade control monitoring, reported in a 1942-43 Tariff Commission report, which adds real doubt about how courts might eventually rule if this action is formally challenged.
This is your second rehook, and it connects directly to the pattern we discussed earlier regarding IEEPA. The Supreme Court already struck down one of Trump's major tariff tools in February 2026 for exceeding the authority Congress actually granted. If Section 338 faces a similar legal challenge, and given that it has never survived a court test, that possibility is genuinely on the table. Canada's patient negotiation-first strategy gains an additional layer of logic. Why match an aggressive tariff with aggressive retaliation when the legal foundation underneath that tariff might not survive court scrutiny at all? There's also a data point that complicates the administration's own justification. Fortune's analysis found Canadian imports of U.S. auto parts have stayed at or above their historical range over the past year, even surging to a peak in March 2026, and now exceed the value of finished auto exports, which they've historically tracked closely. In other words, the exact sector the vehicle tranche was meant to protect doesn't show clear harm in the underlying trade numbers.
So, back to the core question. What did Canada find out that stopped Trump cold? To be precise, Trump wasn't legally stopped from imposing the tariff. The 50% duty is scheduled to take effect August 19, 2026, covering roughly $20 billion in Canadian goods, overriding USMCA entirely. What Canada's teams identified was something more strategic. Once Trump invoked Section 338, he locked himself into its ceiling. 50% is the legal maximum, and the only escalation beyond it is a full embargo, a confrontation neither side has shown any appetite for. That ceiling, plus genuine doubt over whether a never-before-used, possibly superseded statute survives court scrutiny, is likely why Canada chose patience over retaliation. Not from weakness, but from understanding exactly where this particular law runs out of road. The bigger lesson: when a government reaches for a dormant, untested statute to override a modern trade agreement, it usually means the newer tools have already failed. Knowing exactly what a law does and doesn't allow is what separates strategy from reaction. And that's exactly what shaped Canada's response here. Trump thought he'd found a new weapon. Canada realized he'd exposed his own ceiling.